Welcome back to the NonDē Filmmaking Legal Lab. Hi, I'm Mike Rekola, and today office hours go nightly again. That's because it's night 3 of our February clean chain of title sprint. Each day, I've sent out a quick email with a mission designed to be short enough to do before breakfast, but impactful enough to save your production. Tonight, I'm here to be an educational resource for the next 15 minutes or so. Before we dive in, let's go over the quick disclaimers and the rules of the road. I'm an attorney, but I am not your attorney. Nothing we say here creates an attorney-client relationship. This is educational guidance for the independent film community. If you have a specific legal emergency, you need to hire local counsel. Second, please do not share any personal or sensitive information. It's best to keep all questions hypothetical rather than asking direct questions about direct people or problems. Finally, if you'd like to ask a question, you can type it in the chat. Or if you'd like to come up on stage, please type in the hand waving emoji or any other emoji in the chat, and I'll bring you up on stage. When you do, please introduce yourself, give us a quick little log line about what you're working on, and affirmatively state that you understand that this is for educational purposes only, and that no attorney-client relationship is formed. Now let's dive in. So far there has been 4 assignments from our launch day, day 1, day 2, and day 3. Today was day 3, and it was all about locations. The most important thing about a location is you want to have what's known as the kill switch clause, aka the no injunctive release. A disgruntled or no injunctive relief, excuse me. A disgruntled landlord is a dangerous landlord, and if you scratch their floors, they can sue you for damages. But can they stop your movie from coming out? Only if you forgot the no injunctive relief clause. So today's mission was to find your location agreement for your primary sets, rename the file and file it away into the proper folder, which would have been your 4th folder for locations, and then do your quick red flag check. Look for the remedies or the injunctive relief clause. You're all set if there's a shield. It should say the owner is limited to monetary damages at law and waives the right to enjoin or restrain the distribution of the picture. This basically means that if they're unhappy with something, they can sue you for money, but they can't sue you to stop the release of the picture. Now, the risk is if this is missing, a judge can issue a court order to block your release until the floor that is scratched is fixed. So, how do we prevent this? First things first, never shoot without a location release. But if you did, get them to sign a release of claims or a waiver of claims. Otherwise, there really isn't a quick fix. So that was the standard NonDē location agreement. On launch day, let's backtrack. On launch day, we talked about organizational structures. You cannot audit a mess before you look at a single contract. We need a bucket to put them in. That day was about infrastructure. If you did it right, your delivery to your distributor would take 5 minutes and not 5 months of crumpling through papers and signed emails and things. So the mission for our first day on Sunday was simply create 5 buckets, 5 folders, one for your underlying cast, which is your script and story rights. The second one was going to be for your talent, which is your cast. Third one's going to be for your crew, which is your production. Fourth one's going to be for your locations, which is your permits and releases. And the 5th one is going to be for your musical score. So the assignment was to organize those simple folders and be ready. Before I dive into day 1 and day 2, I'll pause for a quick moment to see if there's any questions. If anyone has any questions, feel free to type them in the chat or put an emoji into the chat and I'll try and bring you up on stage. If you do come up on stage, introduce yourself, share a log line about your film, and affirmatively state that you understand that this is an educational resource only. So the first assignment on day 1 was about making sure that your writing, IP, and contracts were completely covered. If you don't own the script, you don't have a movie. So distributors never care about your shot list. All they care about is a clean chain of title. So if it's broken, nothing else matters. So that mission was fairly straightforward. Locate your writer's agreement, option agreement, or shopping agreement. Rename it into the protocol, drop it into the proper folder, which would have been 01 underlying rights, and then do your quick red flag check, which would have simply open up the PDF, search for the phrase certificate of authorship or work made for hire. It passes the test if that clause explicitly states that the production company is the author and the owner. It fails the test if the contract is silent, and generally that's worse because that means that the writer retains the copyright. So the fix, if you're missing the work made for hire language, you need a quick claim deed or a new writer's agreement immediately. Then we went into day two, which was your talent, your actors, dealing with the dubbing clause and the current AI clauses that you want to be concerned with. So actors are the face of your product, but they can also be your biggest liability. If your lead actor decides they hate the final cut, they can block the release. Not if you have the right contract with them. So that mission was to simply find your actor's release, rename it, drop it into the talent folder, and then do your red flag check. Your red flag check was scanning for the grants of rights section and looking for your dubbing and likeness clauses. See, in today's modern environment, distributors are looking for clauses that allow AI for very small things like fixing the blink of an eye or fixing a continuity error, but not to recut the whole performance. So you want to make sure that you can look and see that you have those rights locked away. The fix is not use a release from 1990 that doesn't mention digital rights. And the second is to simply get them to sign a likeness addendum or re-execute your standard release. So we've done 4 days of work. First was organizational. Second was going to be I can't think right now. Second was going to be your talent. Third was going to be your locations. And fourth was going to be your writers. So tomorrow we'll be going over your sound and your sync license. Looks like we have a question in the chat. It says, "Hi, my name's Lucas. If I wanted to enhance the sound/image of my film, what kind of contract would I have to make?" So generally, you don't need a specific contract to enhance the sound or the image. It's just one of those kind of cover your ass clauses that protects you. A lot of times actors won't actually go out there and have a problem with you cutting their performance. But if they did, that clause would protect you. So what you want to do is look for it to be baked into the individual clause for all your actors if you're changing the image of the film, as well as in your DP's contract, say, or your director's contract, because they're doing parts of the visual identity of the film. And then if you're cutting the sound and remixing your sound, you'll see in our composer's agreement and in our sync license the ability to modify the song so that it fits what we're trying to use it for, but it doesn't allow us to completely destroy the song or gut it. I hope that helps, Lucas. But there's not one specific contract. You're just going to want to make sure that these clauses are peppered and sprayed throughout the other clauses for your talent, for your sound crew, and for your picture crew. Any other quick questions? I know today was going to be a quick one. We didn't have a lot to cover. I didn't see a lot of questions ahead of time. But your homework for this week is to keep following along, do each challenge daily, and when you're done, you'll have the perfect chain of title and zero anxiety when a distributor asks to see it. So tomorrow, like I said, we're moving into your composer's agreement and your sync licensing agreement. One shows that you own the copyright from the composer. The other one says that you have the full rights to license it worldwide. It's a very different game in sound than it is in filmmaking, in music than it is in filmmaking. So be sure to follow along, watch the walkthrough, use it as an educational resource, and get out there, get to work. With that, I'll wrap up. Thanks everyone for joining us, and I'll see you tomorrow night about 8:15. We'll be back here with night 4. Thanks everyone.